I'm calling this hearing to order. We are reconvening from recess the Electoral Board regarding matter 2017-MOEB-1 from our prior hearing of January 2nd. And I'm going to ask Ms. Moritz to call the roll call, please.
Commissioner Mannix?
Here.
Clerk Moritz here. Mayor Calderon?
Here. Thank you. So we're going to proceed then with, I'm going to defer to counsel for the Electoral Board, Mr. Bastian, to take up the proper order of business.
Thank you, Mayor. The only matter on the agenda is 2017 MOEB1. Is a housekeeping matter. Can everyone in the back hear me? It's a housekeeping matter. We've had the records examination, so I would, first of all, is with respect to the Rule 6 motions, the respective councils agree that the Rule 6 motions were timely filed?
Yes.
Yes. Okay. If the board would admit, motion to admit as Board Group Exhibit 5, the proponent's motion to strike the objection, the objector's response, and the proponent's reply.
So moved. Just I want to be certain I'm clear. We got the proponent's motion to strike, the response to motion to dismiss, and then the proponent's reply in support of the motion to strike. Those are going to be the three documents admitted
Is Group 6.
as Group 6.
I'm sorry, Group 5.
Okay.
I apologize.
The exhibit's going to be Group 5, correct? Consistent of 3 items. So all those in favor signify by saying aye. Aye. Any objection? Hearing none, we are admitting those documents.
And Board Exhibit 6 would be the results of the records examination conducted by the Cook County Clerk's Office. Gentlemen, any problems with that?
No.
Motion to admit it.
And do we have,
I have copies.
these are 2 copies, 2 of the same, right?
It's the original and 2 copies for the board. I have.
So we're going to admit as Group 6.
Board Exhibit 6.
Board Exhibit 6, the results of the records examination. All those in favor say aye.
We need to go.
Aye.
Motion, I'll make a motion to admit it.
Second.
All right, those in favor say aye.
Aye.
Those opposed, we are accepting the results as Board Exhibit number 6.
And next, it would be proponent's Rule 6 motion as Board Exhibit 7, and Board Exhibit 8 would be objector's Rule 6 motion.
I'd like to make a motion to admit both of those, as stated.
Give that to me one time.
Board Exhibit 7 will be proponent's Rule 6 motion, and Board Exhibit 8 will be objector's Rule 6 motion.
Okay, is there a motion to accept both number 7 and 8 to the board? Got a motion?
Yep.
And a
Second.
second. All those in favor say aye.
Aye.
Opposed? we have adopted and accepted those two.
I would suggest that then the next order of business is the motion to strike. Mr. Mullen, it's your motion, if you will.
Thank you. Is this on?
Hello?
There we go.
If the red light's on, you're on.
Good morning. The proponents of the referendum have filed a motion to strike with respect to 4 paragraphs of the objector's petition. 3 of those paragraphs relate to predominantly the same issue, which is that there were 6 petition sheets inserted in the papers that were filed with the clerk that had a date of November 2016 on those petition sheets, and those were different than the other ones which did not have a particular date for the election. With respect to paragraph 8 of the objector's petition, what they have asked this board to do is to throw out the entire filing because these sheets were included in the petitions that were filed with the clerk. The motion to dismiss relates to the remedy that is sought by the objector to this error. And the remedy they seek is to strike the entire petition sheet, but the case law from the first appellate district and also from the Chicago Board of Elections says that the appropriate remedy for this is not to strike the entire petition, but is to not count the signatures on those pages that are different. And specifically, I'm referring to the Samuelson case, which was cited in our brief, which is a first district appellate court opinion, which said that where a petition sheet was included in a filing that was different from the rest of the filing, the proper remedy for that was to strike that petition sheet. In addition, we cited to the Hendon case of the Chicago Board of Elections, which is very similar to that, where there were multiple pages within that petition filing that were different. And again, the appropriate remedy found for that was to strike only those petition sheets that were different, not to strike the entire filing. So with respect to paragraph 8, we have moved that the remedy sought by the objector to strike the entire petition sheet should be stricken from the objection, and the appropriate remedy for the error is to not count the signatures on those individual sheets that have the November 2016 date on it.
Would it, gentlemen, and I'm sorry to interrupt, would it be easier if we deal with each one individually and respond to applying to the next issue, or what's your pleasure?
I think maybe we could do that if we group paragraphs 8, 9, and 10 together, because they all deal with the same issue, and then go on to paragraph 11, but I'm happy to do it however the board wishes.
Okay, Mr. Murray, how do you? Whatever the board. I just think it might be easier for everyone, including the residents that are here, if we take each one separately, we argue it, it's discussed by the board, and the board enters a ruling either sustaining or denying your motion as to that issue.
Okay, that's fine.
Mr. Neely?
Yes. Yeah, can you hear me?
Yes.
Yes, thank you, members of the board. As to this issue regarding the uniformity of headings, let's keep in mind that this is a referendum case, and therefore it is governed by the referendum sections of the Illinois Election Code, which is Article 28 of Section 10 of the statutes. And there it specifically states, quote, "The heading of each sheet shall be the same, period, close quote." Now, counsel cited the Samuelson case, but that's a difference. That was a candidate petition under Article 7-10 of the Election Code. There's no language in 710 that talks about the headings being the same. So that is distinguishable in terms of the application of the referendum provisions of the Illinois Election Code as opposed to different provisions that govern established political party candidates in a primary election. And we've cited a referendum case that I think is right on point. It's in Ray petition to form a new park district, and it was a first district 1989 case. We cited that in our written submission to the board and quoted from that, so I'm not going to go over it in every detail, but I think there are a couple things that need to be highlighted to the board so you understand the nature of the law in this area. For the purpose of ballot integrity, these petition sheets headings have to be the same. And Valentine's Law Dictionary says the same is alike in all respects, identical. There's no dispute here that there are at least 6 pages here of these petition sheets that reference the referendum being placed on the November 8th, 2016 election ballot. Remaining pages of the petitions that were submitted say that it should be placed at the next regular election. So very clearly that is a substantial difference. It's not identical, it's not the same. One specifies a specific fixed point in time, the other one references an upcoming election without giving a date per se in the body of the heading. And the appellate court in 1989 in deciding the Park District referendum case said that these 28.3 headings are mandatory. And they went on to say, and what does mandatory mean? The Serwinski case that we cited defines mandatory, and that means it's there to protect the integrity of the election process, and they must be strictly complied with. There's no substantial compliance with a mandatory requirement. You can't say, you know what, all but a handful of the pages were correct, so ignore the ones that were wrong and just concentrate on the rest of them. And how do we know it's mandatory? Because the election code uses the term shall. It doesn't say may or should be or try as hard as you can to make sure that it's mandatory, but we're going to hold you to it. No, the language says shall be the same. And we cite the Powell case for the dictate that shall means mandatory when it's used in the election code in that term. And the DeFabio case, which is an Illinois Supreme Court case, says that you cannot substantially comply with a mandatory provision of the election code. So the argument the proponents are making here is we substantially complied, we got most of it right, we screwed up a bunch of sheets, but kind of put those to the side and just look at the sheets that we got right and pretend the other ones aren't there. The DeFabio case says no, if it's a mandatory requirement, you can't do that. You can't say you substantially complied. Either you're in compliance or you're not, and it's a bright line test. We would address the purpose of this, and again, I'm going back to the Park District case. And I'm going to quote from that case in some detail here as we did in our written submission to the board. This is our Illinois Appellate Court speaking. Quote, finally, we hold that the heading requirement of Section 28-3 is equally mandatory. Although we find no case authority that has dealt with this question in Illinois, we feel that the legislature sought to protect the signatories and the electorate from misrepresentation and fraud. And this is what's important here. These petitions were given to people, and somebody was approached and say, hey, would you sign this petition to get this question on the ballot on November 8, 2016? And then that was mixed in with petitions that said, hey, would you sign this petition to get it on the ballot at the next regular election? Well, voters are not being informed of when the petition and when their signature in support of that petition would enable the question to be presented to the electorate. And when that mandatory provision is not met, when people are allowed to mix and match and say, I'm going to throw in some that have one date, I'm going to throw in some that say something different, then the integrity of the election process is at stake. Because in those situations, the voters who are being asked to subscribe to that petition to get that question on the ballot are doing so for a particular election. And when that is, the voters' will is frustrated where you don't put the question on for that particular election, but instead you mix and match petition sheets and file them for an election at a later date, that's a misrepresentation of those voters. Because those voters may have said, you know what, I'm all for dealing with this question in November of 2016 once and for all. And if you guys don't get it right, one way or the other, I'm not going to sign a petition for a future election. And the Zapolsky case is again cited in our brief. And that says something very important. That says if there is a basis for confusion in the petition submitted to the voters, the petitions are stricken. And that is an issue of law, is what the Zapolsky court said. That's a 1998 Illinois appellate court case. Because what they said there is, you don't have to bring in people to say, I was actually confused. Because it's an issue of law, if you look at the plain meaning and the plain statement contained in that heading, and you see that that is confusing, and it's not identical, and it's not the same, that's all that the law requires for an electoral board to say, you know what, on the face of the document, it's confusing. On the face of the document, it does not comply with the mandatory requirement that the headings be the same, and it has to be stricken. And that's exactly what we've argued here in these petition paragraphs, is that this is confusing on its face. You don't have to bring in 5 or 10 or 50 voters to say, I was confused, because it's a matter of law. That's what the courts have decided. So it's for you as an electoral board to look at it and say, is November 8, 2016 different than the next regular election? And if you believe it is, in the plain meaning of those terms, and this is a mandatory provision, then you have to decide that all the petition sheets have to be stricken because the headings are not identical. The headings are not the same as mandatorily required under the referendum provisions of the Illinois Election Code. And again, the cases that deal with a candidate who had different petition sheets mixed in with his, there's no such provision in Section 710 that governs candidates. You're here to decide under Article 28, the referendum provisions of the Illinois Election Code, whether this meets the requirements. And when the requirement is the heading of each sheet shall be the same, you have to interpret that mandatorily and literally. And right on the face of the documents that have been submitted to you here, that's clearly not the case.
A question for Mr. Nally. Mr. Nally, what was the infirmity in DeFabo? What was...
That was initialing of ballots by an election judge.
Okay.
And I cited that for the proposition, what our Supreme Court said, though, if it's mandatory, you can't substantially comply. Factually, it's different, but it's the point of law that's important there, is that if a mandatory provision of the election code is not complied with, you can't say we came close enough. It's either right or it's wrong.
And doesn't, with respect to, you referenced Section 710, but Section 10.4, form of petitions, and I believe that's for independent candidates, doesn't that require that the heading of each petition sheet shall be the same?
That does, but the Samuelson case cited by the proponents here was a case brought under Section 710. So it did not interpret anything in Section 10.4. So it's a 710 case.
So I had suggested we talk about section paragraph 8 and paragraph 9 together because they overlap with one another, and Mr. Nally in his argument went on to talk about the Zarolski case, which he had cited in paragraph 9, and talk about confusion. So I hadn't addressed that in my original argument, so I will here. But first, I would like to address the question of the New Park District case that was cited by Mr. Nally. In the New Park District case, there was an error on the heading in every single petition sheet. It was insufficient because it did not inform the voters when they looked at the petition sheet that in order to form a new park district, old park districts would need to be dissolved. And the court found that that was misleading, and that confusion was not just on some of these sheets, it was on all of the sheets, and that is why it was stricken in its entirety. And I think if you look at the question of confusion here, the people who signed the correct petition sheets that did not specify an election were not confused at all. They looked at the petition sheet, they signed the petition sheet, and that petition sheet was not confusing in and of itself, and those signers were not confused. Someone who signed the petition sheet that had the November 2016 date on it, that was incorrect, so they may have been confused about the date on which that election was going to be held. Of course, you know, we would submit those people still want this on the ballot. It was just a question of when. But to the extent that those people were confused, the confusion is completely eliminated by getting rid of those sheets. The sheets remaining that were correct, there is no confusion whatsoever to the voters about those particular sheets, and that's why they should be counted. The other two cases that were discussed by Mr. Nally in his argument is the Zapolsky case, which also dealt with confusion. And in that particular case, the confusion again was on all of the sheets. The question was, what office was the individual running for? Were they running for a 4-year term or a 2-year term? So the confusion was on every sheet that was signed. Here, the confusion could only be with respect to the ones that had the November 2016 date, and that confusion, to the extent that it might exist, is completely eliminated by not counting those sheets. Then with respect to the question of substantial compliance with a mandatory provision of the election code, you know, if you look at the DeFabio case and you look at you know, pretty much any of the cases dealing with mandatory provisions of the election code, the courts have held that substantial compliance is sufficient. In the DeFabio case, what they did was they went one step further and they said, is this affecting the integrity of the election process? And if it affects the integrity of the election process, we're not going to allow substantial compliance because that does not uphold the integrity of the election. Here, you have a provision that says that all of the headings must be the same. So you can achieve that simply by deleting those 6 sheets that are different. You don't have to get rid of the entire set of petition sheets. And there's no confusion to the voters that sign those sheets, and there is substantial compliance with the provisions of the election code relating to the referendum.
Yeah, and now for me, I'm going to defer. Board members, if you have any questions.
When you're talking about the headings of the petition sheets all have to be the same, they're not the same. How do you determine which, if you're trying to say, okay, well, just eliminate some of the sheets, how do you determine which sheets you eliminate to make them all the same? You go with the one that has the most that are the same, or, you know?
I think that's a determination that the board makes. I think here it's clear that there was one circulator who circulated the sheet that had the November 2016 date on it. All of the other circulators, all of the other pages had the date, or had no date on it. The petitions were filed after November 2016, so it's clear that the intent of the proponents was not to have it on the November 2016 ballot. So I think looking at the entirety of the circumstances here, it's very clear which sheets should be thrown.
Thank you.
If I could address that, I think it's important to look at that date and get back to the language that the appellate court in the Park District case gave us. It said 28.3 is mandatory. That means the entirety of 28.3 is mandatory, the heading provision in particular. So it didn't say that we're going to make exceptions. It says each shall be the same, and they're not. And the court, as I mentioned, went on to say that the purpose of that is to protect the integrity of the process and avoid misrepresentation and fraud on the electorate. So if you're getting people signing a petition for November of 2016, and then you realize, you know, we don't have enough sheets, we're going to just hold on to these petitions and roll them over and use them over again. That's the exact misrepresentation that the mandatory requirement is designed to prevent. You can't mix and match pages and wait till it's most opportune for you as a proponent to say, now I think we have enough and we're going to present this to the voters. You're asking the voters to sign for a particular election, and actually we have raised this in our objection as well, that the majority of the sheets here were notarized prior to the last regular election, which was April 4th of 2017. And when people were signing those then, at the time they signed them, the next election was April 4th of 2017, so we think there's even more of a basis for confusion and misrepresentation in the other batch of sheets. But you raise a good point. Which do you pick? If they're different and they're not the same, do you say the November 8th ones are the ones you roll with, or the other ones are the ones you roll with? And that gets back to the whole purpose of the statute. You can't roll with one or the other. It has to be identical, it has to be the same, and if it's not, you strike them.
Any other questions at the moment? I want to be certain I'm kind of clear in my mind. We've got two different arguments obviously going on, and one is pertaining to the strict language of 28.3, and then the other argument is speaking to, I believe, the Samuelson case. And direct me, what part of the code would the Samuelson have dealt with?
That was
710.
710.
That's the 710, okay. So I think I'd like to have a little more, at least discussion on, what's going to differentiate these two arguments.
If I may, listening to arguments of both counsel, the issue, as far as I'm concerned, is the statute does say the headings shall be the same. In many of the cases where substantial compliance is argued, there's an infirmity throughout each petition. The next issue is, what is the remedy? Now, we're dealing with the 6 sheets that reference the November 16, 2016 election, because that's what was raised in the objection. I think substantial compliance also applies in this case. 6 sheets out of 276, I believe, carry the different language. The November election is passed. Those sheets, obviously, wasn't on the ballot. But I think the appropriate remedy is to strike those 6 sheets as opposed to all 276. Mr. Mullen's argument is well taken. Is there confusion? Yes, but it's confusion only in the minds of those signers of the 6 petition sheets that reference the 2016 election. I think there is substantial compliance, and I analogize this issue to those cases where, for whatever reason, candidates included nomination papers or nomination petitions for a different office or for a different political party. Somehow they were included in the petitions that were filed. There are cases from the Cook County Board of Elections where 9 signature sheets from a candidate from the opposite party were mistakenly included in the other candidate's petition packet, and they struck those. They treated it as surplusage and did not throw out all of the petitions. In my mind, these are mandatory provisions. There is substantial compliance, and the remedy is to remove the 6 sheets, not all 276.
If I could be heard, though, I'd just like to point out, I'm reading from 710. 710 talks about the heading that needs to be on a candidate petition sheet for a established party primary, and it says the following. That the sheet shall be in substantially the following form. So 710 allows for substantial compliance because it uses the term substantially in this form. So if there are minor defects, there's wiggle room in 710. 28.3 does not. It says the heading of each sheet shall be the same. And our appellate court in the Park District case said, yeah, because this is a referendum and it's different than a candidate petition, and the language of this petition has to be in mandatory compliance. So the substantial compliance cases that talk about 710 right in the text of it says shall be in substantially this form. So it allows for some form of substantial compliance. 28.3 does not. It shall be the same, and it's mandatory, and that's what the courts have told us.
The only thing I would say is that Mr. Nally is correct that it says substantial in 710, but there are places throughout the election code that just use shall, that courts have found substantial compliance is sufficient, and I think some of those cases are cited within the cases we cited, but given that that's a new argument, if the board is willing to look at that, I'd request an opportunity to show that. I think there's got to be at least a dozen cases where you have substantial compliance with a mandatory provision without the word substantially in the statute.
Including section 10.4, which I referenced before, says shall. Again, I think the issue is there voter confusion? Yes, there is as to those 6 sheets. Has the integrity of the electoral process been tainted by those 6 sheets for whatever reason they're in there? If you have a circulator who doesn't follow the rules, depending on violation of the election code, you throw out those circulator sheets or the bad signatures. I just think the board, certainly the board's decision, the remedy is to strike the 6 sheets.
I would just invite the board to look at 28.3, which governs referendum, not candidate petitions. You're not going to find cases that say substantial compliance is enough, because the plain language of the statute in the Park District case says, no, it isn't.
It does nothing other than add additional confusion, in the decision-making process. Because I took the time and read the Samuelson case, and one side of me understands it, and there they opined that there was substantial compliance, just as Mr. Mullins has argued, and I get that. But yet at the same time, when we go to 28.3, Mr. Nally is correct in your argument. It clearly says shall. So then, at the end of the day, then we're left with trying to say there is no court case to opine on 28.3, but we do have one on 710.
Well, there is the Park District case.
So let's talk about that Park District case then, just a little bit more, so I want to be clear in my mind. Because I, for some reason, did not read that case. That was the new Park District?
Right.
Was it? Okay. And where was this heard? Where was that case heard?
The first district case.
Where?
Where?
First Appellate District.
Okay.
Can gentlemen expound on that a little more, please?
Pardon?
If you can.
Yeah, I'd like to talk a little bit more about that case, if either counsel is prepared to either argue in support or against?
Well, I've argued in support of it because I think it's the binding law. And it's pretty simple. You look at the plain language of 28.3, it says shall be the same. And then the court said, in the Park District case, up to then there hadn't been any law in 28.3 in the mandatory provisions. But now the Illinois Appellate Court in Cook County is making the law. And this is a law that's binding on this board. And it says it must be strictly complied with. Again, we cite certain portions of that decision in our written submission to the board. And I'll quote from this is at 538 Northeast 2nd, 849 at page 854. And it says, we hold the heading requirement of section 28.3 is equally mandatory, meaning it's a mandatory provision. And it says we don't find any case authority because they're making the law on this until then, but they say now it's to protect the signers from misrepresentation and fraud. Maybe I'll draw another contrast with section 710. A candidate who's running is a party candidate to run in a political party primary, as was the Samuelson case situation. That person has 90 days to start to finish to circulate petitions. They start in September, they have to be filed by November. So there's a very thin timeline there. And maybe they're a little more forgiving because of that timeline. Here it's even more egregious, where you can take petitions that you circulated for one election, lump those in with petitions that were circulated prior to the next regular election, which would have been the April 4th election. Let's be clear here. Of the petitions that were submitted to this board, the only ones that show they were notarized after the April 4th, 2017 election are pages 239 to 247, which contain 109 signatures. So I'm saying that these headings, first of all, are not the same, and second of all, the purpose of the statute and the mandatory provision in 28.3 is to make sure that there's no misrepresentation. So we have people who were misrepresented by saying sign this to get it on the November 8, 2016 ballot. Then we have people who were misrepresented by saying sign this to get it on the next regular election ballot, which at the time they signed it, when these things were notarized in 2016 and up to March of 2017, the next regular election was April 4th of 2017. So exactly the problem that the mandatory provision was designed to address is present in this case, is that the headings were misrepresented to the people who signed them, that number one, it would be on the November 8th, 2016 election ballot, and number two, it would be on the next regular election ballot, what would have been April 4th, 2017. And you can't allow people to hold these petitions forever and ever and ever and decide now we think we finally have enough signatures of people who may have died, who may have moved out of town in the interim from the time they signed it, and we're going to submit that as our number. So I think the Park District case is clear as to referenda, which this is. It's not a candidate petition, that it's mandatory, and if there's any differentiation in the headings to preserve the integrity of the election process, you strike everything.
The new Park District case did not address the issue of whether the headings were different. In that case, the heading on every single petition sheet was the same. So the question of how that impacts this case is not nearly as much as Samuelson, which dealt with that particular issue directly. In New Park District, what they said was that it was mandatory that the petition tell the voters what the impact of the referendum would be. And that was the confusion. Here, there is no similar confusion. If you take out the sheets that have the November 16th date on it, anyone who thought that this was a referendum only for the November 16th date, any confusion that they had is completely eliminated. So New Park District is not, it is a referendum case, and it does say that it has to be, that there is a mandatory requirement that the petition not be confusing. But the reason that's mandatory is it goes directly to the integrity of the election, Because if the referendum itself is confusing and people are signing, every person who signs that petition sheet is signing something that is potentially confusing, then it makes sense to throw out the entire petition because all of them are tainted by the confusion or fraud or whatever it is. Here, you've only got 6 sheets that have any potential confusion relating to them. All of the people who signed the petition that did not have a particular election date on it, none of those people could possibly be confused about when or what the purpose of that referendum was, and therefore those signatures should not be thrown out.
The difference is 710, right in its text says, you can substantially comply. It shall be substantially in this form. It allows for some differences. This doesn't. And the appellate court didn't say parts of 28.3 are mandatory in the Park District case. It said, we hold that the heading requirement of section 28-3 is equally mandatory. It didn't say you can still substantially comply with sections of it. It says the heading requirement is mandatory, and that means mandatory.
I recall going through, not identical, but a similar situation. We had an electoral board hearing, a couple of years ago, something like that. There was a question about whether or not the signature count, do you remember this? And it was, argued both in support and against that you got close enough. There was whatever the signature count, that it didn't meet the exact threshold, but it was close enough. And I think that there were arguments went on for a good hour and a half, and we finally came to the conclusion, based upon whatever that court case was, that that there was an absolute requirement. There was no such thing as, we're almost there, we're kind of close. But I think so really what we have to decide on is, on this particular matter, is whether or not to just pull out those handful of sheets, or to throw out all of the petition sheets.
I may, Mayor, with respect to the close enough as to signatures, the Supreme Court addressed that 2 years ago. I believe it was a mayoral candidate in East St. Louis or something. Said, well, I had almost enough signatures. It went all the way to the Supreme Court, and correct me, gentlemen, if I'm wrong, the Supreme Court said, no, when it comes to the number of signatures, there is no substantial compliance. There's no wiggle room. Here, frankly, Mr. Mullen is saying, in the new Park District case, there's confusion in the heading of all of those. Not unlike we've seen recently, a lot of municipalities are having term limit referendums. And the objections have been that there is confusion in the heading throughout every one. I think the issue here is there is confusion as to 6 sheets. What is the proper remedy? Either throw out the 6 that are non-conforming or throw out 276. With respect to confusion, the only people, and in this regard I agree with Mr. Mullen, the only people that are confused are those people that signed the 6.
Having heard, do you have any questions?
I'm having a real tough time getting past the fact that there's nothing in 28.3 that says substantially comply or get close to. You referenced the Video Gaming Act and talked specifically about how you put a petition together. Nowhere in there does it say try, get kind of close. It says shall be. It says that in 28.3, shall be. It's not try. So if we're going to go down the path of saying, well, it says it has to be, but as long as it's close, well, I think that's going to take us down a rather scary path when we start getting into the binder check of, it says it shall be a registered voter in the Village of Forest Park. well, they thought they registered, but they really didn't, so we're gonna go ahead and say shall doesn't count for this particular page and line number. We're just gonna give them, just do a gimme on that. I think it's clear. The language says shall be the same. Not substantially compliant, not close. Shall be the same. 28.3 speaks to that. Anything dealing with candidates, it doesn't apply here. It's a completely different section of the election code. I understand that we don't have case law that's kind of overriding where the direction we should go on this, and that's unfortunate. I really wish there was. But when I, as a non-attorney, read 28.3, shall be the same. To me, shall means must. No deviation on that. The sheets are different. I'm not going to opine about confusion or anything else. I don't think that plays any part of it. You read the plain language in the statute, shall be the same. Shall is must. They're not the same. It's unfortunate. That's what the law says. We're beholden to read the law and interpret it. It says shall be the same. It's not.
I see, for me, I see both sides, but in this instant case, since it is, the 6 sheets represent really, really, really such a small fraction of the overall petitions. I think it'd be best to maybe just throw out those 6 sheets and let the balance remain, and then we continue with other motions that are before us.
So are we gonna talk about the dates of these petition sheets on a separate section?
I'm sorry, there are other objections as to, it should have been on the April 7th election or signatures prior to April 7th should not be considered. That's a separate
Because
issue.
some of these sheets are notarized from October of 16 and.
But that's a separate issue. The issue is there confusion? Is there substantial compliance? If there is, what is the remedy? That is the issue, as the mayor pointed out.
There's only one of 2 courses. You either throw them all out, or you remove those 6 pages.
Well, is there anything that says, any of this case law on referendum that say that you take out the bad sheets, or the ones that are different, or the ones that aren't the same?
Well, I think the analogy is to, again, my analogy is to certain candidate cases where a candidate included, for whatever reason, 6 or 8 or 1 or 9 sheets for a different office or a different candidate. The electoral boards and the courts have held the remedy is you remove those sheets.
In the candidate, that's section 7, correct, it says substantially compliant, getting close. Where they actually put that provision in there is as long as you're getting close, it's okay. Where, again, I'm waiting for someone to show me in 28.3 where the word substantially compliant is in regards to the headings on the petition.
So unfortunately, I don't think there's a whole lot to guide us in answer to Ms. Moritz's question. They absolutely are 2 different sections of the code, and for 2 completely different purposes. Electing an individual to public office versus, in this particular case, which would become a binding referendum, they truly are apples and oranges. And so it does become even a little more difficult then to, draw some analogies between the 2. And there may have been some good wisdom when they crafted 28.3 as to say, or to use the word shall, because the outcome of binding referendums are significantly different than electing an individual to public office. One has, binding referendums have an effect of direct democracy versus representative democracy. Binding referendums have an effect of bypassing the legislative process, which has been the pinnacle, the foundation of our entire country. And so naturally, the law should be different for some of these referendums versus somebody running for public office. But I think that we should be cautious about, maybe best left to a judicial review, for instance. If we were to say, let's just throw out the 6 sheets and, let a court of law determine whether or not there should be strict compliance, absolute strict compliance with 28.3. No exceptions. They might be better suited, if that was the case, to opine.
And how would that happen?
We have quite a
Whatever
number
way
of
you
steps
want.
to go through yet, but
But if we rule a certain way, then whoever doesn't agree with it can bring it to a court of law?
They, under the provisions of the
If they choose.
election code, they have a period of time to file a petition for administrative review.
And it happens. That's in fact what many of these cases that were cited were cases that went up for some kind of review based upon a decision of an electoral board, where we'll call it the losing party, didn't agree with the decision.
And when they review it, they're reviewing whether or not we made a mistake,
Well,
or
it's-
whether we followed the law, or
Well,
misinterpreted
If
it?
it's a question of law, the review is de novo. But the issue before us is, should the proponent's motion to strike those portions of paragraphs 8, 9, and 10 to throw out the entire petition or in light of the 6 non-conforming sheets, should that be granted? Which means then the 6 sheets would be deleted, but the entire referendum packet, the entire 276 sheets would not be thrown out.
You just said paragraph 10 as well on this, which is a pattern of fraud. I don't know that we heard arguments as to,
I think that is a different,
okay, because you said 8, 9, 10, I just, are we,
Mr. Nally, do you agree that the pattern of fraud isn't applicable to the 6 sheets?
The pattern of fraud argument, it's somewhat entwined with it because you deceived voters that they were going to be signing a petition to get something on the ballot in November of 2016. But it's broader than that, and I alluded to that earlier. It's every petition sheet that was notarized prior to April 4th of 2017 that said at the next regular election. So it's a combination of both.
Commissioner Mannix, with respect to the pattern of fraud, depending on how pervasive it is, for example, if a circulator doesn't sign in front of a notary, if a circulator is allowing other persons to sign, not in their own proper person, that pattern of fraud, in my mind, the remedy is to throw out those sheets. So if there is a pattern of fraud with respect to the November 2016 election, I think the appropriate remedy, given the number of signatures on the remaining petitions, is to remove those 6 sheets.
So I guess I'm just struggling with the remedy, because they aren't the same. And I'm struggling with that.
Those 6 sheets.
Whether you throw out 6 sheets or 270 sheets,
Right.
how do you differentiate what sheets you're gonna get rid of?
Well,
And who determines?
This
what's
is the
right.
first issue. Are the 6 non-conforming sheets, do they taint the whole electoral process or the referendum process? Or do you remove those non-conforming 6 sheets?
And then
That's where I'm
continue-
struggling.
And then continue with the balance of, you know, the other arguments. What do you mean by it's deciding which sheets do you take out?
Well, we know that they're not the same, and so I'm struggling with what the remedy is if we allow them to leave the other 270 sheets as valid and just throw out 6 sheets that don't have the same heading, if that's the right remedy.
The issue before the board with respect to this portion of Mr. Mullins' motion to strike is the 6 sheets. There are other arguments with respect to his motion to strike other portions of the objection. We are only dealing with the 6 sheets.
I understand, but I don't feel confident that taking out 6 sheets is the correct remedy.
If someone wants to make a motion one way or the other, and we'll take a vote if that does not prevail.
Let us.
I don't know that I'm ready to vote yet, so, sorry.
I'm still struggling with the shall. Shall means must, right? Just looking at the petition, the heading itself, right? Shall video gaming be prohibited in the village of Forest Park, Illinois? You vote yes, it will be, and it carries a date, it will be prohibited. Not maybe prohibited, not kind of prohibited. Shall, it means must, right? There's no wiggle room on that. There's no substantially compliant. I'm really struggling with this. You know, 6 sheets taint the entire packet. Well, arguably, you know, they're not compliant. It's strict compliance. 28.3 says, shall be the same. Mr. Nally's side of the case says it's strict compliance with 28.3. I'm having a real hard time with it. I don't know that we could speak to voter confusion or what have you. The law is the law. It seems like it's pretty straight, clean language.
But of course, part of that is why we're here, right?
Understood.
Because there's, you know, differing views. You know, I'm kind of looking at it as if there was maybe 50% plus 1 of the 200 and some sheets. And that would be a little more compelling to me that there was some absolute confusion maybe taking place. This is really, really a small amount. It's very small.
Yeah, I'm not even really thinking about the confusion side of it. I'm just thinking about the shall,
Mhm.
you know, the strict compliance.
Again, I believe it's strict compliance heading. There's confusion. These are 6 sheets that were mixed in for whatever reason. And again, if there is substantial compliance here, so what is the remedy?
I don't, and again, I keep going back to 28.3, looking for some place in there that we can point to in 28.3 that says substantially compliant or substantially the same. And that language is just not there. It's different in the referendum 28.3 section of the election code versus candidate, where it's clear that language is in there. It gives you an out. It says substantially compliant. You can get close, but not all the way there and still be okay. It doesn't say substantially compliant in the Video Gaming Act when it references petitions. It doesn't say that in 28.3. I looked for it. I couldn't find it. And I wish it was there so we could hang our hat on it, but it's just not there.
Well, it's not a question of the Video Gaming Act. It's not a question of the wording of the public question. What is at issue here is 6 sheets that were included in 276 that have a different heading. Is it appropriate to remove those 6 sheets or remove 276 sheets? Gentlemen, would you like to weigh in any further? Or?
Do we have to decide these in order?
Yeah, we're strike. This is the argument that's before the board now.
What I'm saying is, can we pass on this and go to the next issue? Because I
Certainly.
can't tell you that I've
We
made a
absolutely-
decision.
we-
I feel comfortable with the decision right
Yeah,
now.
And I respect that. We absolutely can do that. So the board is going to withhold immediately ruling on this first motion, and we're going to continue on.
Well, I think the next thing to address then is paragraph 11, which deals with the objection to signatures that were placed on the petition sheets prior to the last election in April of 2017. And the objection suggests that any signature prior to the last election, which is April 2017, on these petition sheets is not valid. And there is absolutely no statutory language or case law that has been presented by the objector in support of this particular argument. The key to the objector's argument is their statement that the petition sheet says that, sorry, I'm looking at the wrong one. The voters will vote on the question at the next regular election. And objector puts a period there, as though the petition just says the next regular election. But what the petition actually says is the next regular election occurring not less than 92 days after the filing of this petition. So this does not say that it's going to be filed prior to the next scheduled election. It says that this is going to be put on the ballot at the next election occurring not more than 92 days after the petition sheets are filed. Not less, pardon. The election code, and we've actually referred to this earlier, says that if you are a candidate, you only have 90 days to circulate petitions. So in this cycle, you had to start September 5th, and any petition signature that was gathered before September 5th is not valid. So the legislature, when they want to put in the legislation that there is a time limit on how long the signatures are valid, they know how to do that, and they've done that. Here, they have not done that. There's no statutory language, no case law saying that these signatures expire. And in fact, there's a word for it in Illinois election law, which is that the signatures are evergreen. And that's a standard practice, although there's no published case law upholding that, it's standard practice in Illinois election law that you have evergreen petition signatures, and there's even a word for it. So we would ask that you strike the argument in the objection that says any signature signed before April 2017 does not count. The reason for that is the objector has not provided any reason in the law why it does not count. The law, when it wants to limit the amount of time that a petition signature is good, it does that. And in this case, there is no limit. And finally, the clear language of the petition isn't that this is going to be put on the ballot at the next regular election. It's going to be put on the next regular election not less than 92 days before the petitions are filed. So there's nothing that says that any signature prior to April 2017 is not a valid signature. And so this paragraph of the objection should be stricken.
The next regular election, when you look at the notarization dates on these petition sheets, for virtually every petition sheet, but pages 239 to 247, those are the only ones that were done after April 2017. Each and every one of those says, the next regular election, not less than 92 days. Well, that election occurred, and we submitted a proclamation of those results as part of our response. And you can take official notice of that from David Orr's office. The next regular election was April 4th of 2017. Sheets 1 through 186, based on the notarization dates, were all signed prior to November 30 of 2016. Sheets 187 through 219 were all signed prior to December 31st of 2016.
What were those page numbers?
187 to 219 were all signed prior to 12/31 of 2016. So basically, pages 1 through 219 were all signed by voters prior to December 31st of 2016. That all would have been 92 days prior to the April 4th election. If those sheets are invalid, the petition is woefully under the minimum number of signatures. And we believe it is because, again, let's get back, and I have to come back to the Park District case because that is the case that interprets the referendum section 28.3 here and what the importance of all these headings are. And this heading said, we're going to submit this at the next regular election not less than 92 days away. Well, the next regular election would have been April 4th of 2017 that fit that bill. So people are signing that based on that representation. And I disagree with counsel. I've never heard this term evergreen before in my life. I've been doing this almost 30 years. It's an interesting term. I give him credit for his innovation. But I've never heard that.
Nor have I.
I would prefer to say, in contrast to evergreen signatures, you can't have dead wood signatures. And the dead wood is that people signed it more than 92 days prior to the next regular election. And then for whatever reason, the proponents decided it was strategically to their advantage or whatever to hoard these papers, just like they did the November 8, 2016 pages, and submit them at a time that they felt would be advantageous to their position. You can't do that. We get back to what the Park District case said about the integrity of the election process, misrepresentation, and fraud. If people sign these saying, I want this on the ballot at the next election, not less than 92 days away, they signed that to get that on the April 4, 2017 election. They weren't filed or submitted for that election. So, despite what the argument of counsel is here, you can't hold these petitions forever and ever and ever and ever and decide, you know what, we're going to submit it now. My grandpa signed it, my grandma signed it, they died months ago, but their signatures are going to be used to support a referendum that's going to affect the lives of people who are still with us. And truckloads of people have moved in and out of Forest Park within that time period. And are those people then entitled to get have their signatures used to get something on the ballot that's going to affect not them, because they're gone, but that's going to affect the lives and livelihoods of people within the village of Forest Park? This idea that you can hold petition sheets until you decide it's the right time you want to file them is wrong. And the statute is very clear on that. And that's why we said here there was a fraud and a misrepresentation on the voters, because they were told the next election, 92 days, we're going to file it for that election. They didn't. And the overwhelming, other than the only sheets that were notarized after the April 4th, 2017 election were sheets 239 to 247, which would encompass no more than 109 signatures. If those are the only valid signatures that they properly filed on, obviously that's way under the minimum number of signatures, no matter how you do the math. So we believe that that is a well-taken objection, as were the prior objections, and as a matter of law, these sheets need to be stricken for that reason.
Again, there's no statute, no case law saying that the signatures prior to April 2017 are not valid. The statute on referenda gives people two choices. They can pick a date or they can not pick a date. And here, they didn't pick a date. The reason you can do that is because people may not want to file at the next election, or they may not know at the time they start circulating when they want to file. So the statute gives them the right not to put a date on it. So if you are saying that anything signed prior to a certain date is invalid, then what you are in effect doing is amending the statute to say, not that they don't have to pick a date, but that it's either they pick a date or it's the next regular election, which is not what the statute says. So you have two choices, you pick a date or you don't pick a date. Here they did not pick a date, and therefore there's nothing that says signatures before a certain date are not valid signatures. And again, I would refer specifically to the language of the petition because counsel for the objector leaves out the key language, which is 92 days after the filing of these petitions, which says clearly to the voters signing it that when we file this petition, they will be on the ballot at the next regular election, not less than 92 days after we file the petitions. So it's clear to the voter that the proponents have not picked a date. They're not saying it's the next election. They're not saying it's the second election. They're saying it's not less than 92 days after we make the decision to file these petitions, which is precisely what the law allows.
Where do I find reference to evergreen?
It's just a term, Governor Quinn uses it. He circulates a lot of petitions, and he's got these ones for the mayoral race, and he calls them evergreen, and I've heard it over and over.
Legal I've not heard it either. It's a good term, but
Okay,
I've never heard it.
I've heard it multiple times.
I prefer dead wood.
But
That's
On the arguments, I agree on one part, I disagree on another part, I do agree. The petition sheets are very clear. It does say 92 days after the filing of the petition. That part's very, very clear, but yet on the other hand, I'm a little bit struggling with, and in fact, there was one of these court cases, they didn't rule on it, but one of the judges spoke to the issue of how long can circulators collect signatures? Can it go on? Can I start collecting signatures today for some type of action, in this case a referendum action, that I want to introduce 10 years from now? And is that right? I mean, because technically, in a matter like this, you're asking registered voters of the local jurisdiction, because I think that's what the election code says, in order to get a referendum on the ballot, I can't go to Kansas City and get people to sign my petition sheets from there, can I? I mean, they need to be registered voters of the local jurisdiction. And just anybody in a reasonable mind, I think, would come to the same conclusion if I started collecting signatures today for an action that I may take 10 years from now. Maybe all those people are still living here, but chances are pretty good many of them are not. And then should it still be valid? So I'm torn on that whole issue. I don't know about this evergreen. Maybe I'll break and give Pat Quinn a call. I've got his cell phone number. Maybe he can fill me in on that evergreen issue. Counsel, did you have something?
Yeah, this is an area of the election code that is probably in need of some revision to make it clearer. The candidate circulator petition circulation period is 90 days prior to the last day of filing, but that's for candidates. With respect to referendum, I believe the only restriction is in section 28.9, which talks about constitutional amendments or statewide advisory amendments, which is 2 years. I think the argument Mr. Nally is making is, and correct me if I'm wrong, that this has created confusion as to when signers may or may not expect that it be on a ballot. But with respect to a specific provision limiting the time for circulation, there is none. It would make it a lot easier if the legislature spoke to the issue. So,
Right. And if I may, I mean, I think your hypothetical is very interesting, and there's no case law in here, but you're talking, I think the earliest was October of 2016, and, you know, the idea that you'd be able to circulate between October and, you know, early December when these had to be filed in order to get on the April 2017 ballot is a high hurdle. And here you're not talking about going back, you know, that many years. You're talking about you're going back just a little over a year before these were filed.
And I guess my point, I just make clear, is this is where it's confusion, and this is misrepresentation to the voters who were asked to sign. Because the document they signed said the next regular election not less than 92 days, which would have been the April 4th of 2017 election. So I'm saying in this case, the voters had an expectation. If I'm signing now in October of 2016, the next regular election is April of 2017, that's when I expect to see this question filed and put forward.
Board members have any questions?
I don't have questions, but I do find the heading to be confusing, especially for the people that, or for the sheets that were notarized back in 2016. I think that when people are signing a petition, and you were saying you can either pick a date or don't pick a date. You didn't pick a date, but you said the next election, which is not less than 92 days, you know, after we file the petitions. I think that's confusing, and I think that, you know, 92 days before the April 4th would be somewhere around January 2nd, January 3rd, I don't know exactly, but a lot of these petitions are notarized way before that. So they were circulated before they were notarized, and I think that it's confusing. The 92 date provision on the top of the petition is confusing to the person that's signing it. It would be. So you didn't not pick a date. You didn't pick a date, but you didn't not pick a date. It seems to me that you were saying that it was going to be filed with, you know, the next election not less than 92 days, and it really wasn't.
I think it says after the filing.
But after the filing.
I
After the
understand, but I
filing.
think that's confusing for a person who's signing a petition. You didn't pick a date, but you didn't really leave it open.
If it was a candidate filing, we wouldn't be having this argument because there's a start time and an end
I
time.
understand.
This becomes confusing on a whole number of fronts. Any other thoughts, comments, questions?
I have a question. So you can circulate a petition for a binding referendum and not specify anything about when it'll be on a ballot?
Yes.
So you didn't need to put the not less than 92 days on there?
Well, I'm not going to speculate as to what they needed. There was another case. Again, with respect to this, the election code does not have a date when it may be circulated, or a sunset, in this case a sunrise provision.
Actually, it's in 28.3E, and it says if a petition initiating a public question does not specify a regularly scheduled election date, the question shall be submitted to referendum at the next regular election not occurring less than 92 days after filing.
So they needed to put the 92 days
Yes.
on there?
And that was-
Either a firm date like November 8, 2016, or 92 days.
Thank
So
you.
92 days.
And where'd you cite that from, 28?
28.3E. Pardon me, 28-2E, I misspoke.
Want to read it? Yeah. It looks like it's substantially taken out of the
Election code.
election code, the language. Other than the 6 sheets. It's taken right out of the language.
Question two, this is, we're still at the motion to strike. Depending on how the board ultimately rules on that, are you going to stand on those arguments, or?
Yeah, I'll stand on the arguments, the legal issue is the same. So whether the board grants or doesn't grant the motion, depending how the board rules on that, then if they were to not grant the motion to strike, then I would expect the board would grant the objector's petition in that issue.
I agree.
Okay, you did not intend to bring anyone in to test, no live testimony that they're, okay, because it is just a legal issue. All right.
You want to move on this matter now, or differ?
Just give me a minute, okay?
The next matter is the deviating from the 25%.
And obviously, we don't expect the board to overrule a state statute, but, it's in there for preservation of our rights.
That's what I-
It's rather humorous, you said you don't expect us to overrule a state statute when you, previous arguments asked us to.
Pardon?
Well,
Yep.
well, if... Okay.
See? And this deals with paragraph 11.
Paragraph 11. In the effect, if the board granted the motion, then all sheets but the last, what did you say,
239 to 247.
would be stricken, correct? I want to make sure that...
I'm not sure the exact page numbers, but I think the ultimate outcome would be the same regardless of the page.
Okay. I just want to make sure everyone's on the same page, if you will. If the motion to strike is denied, then the effect of that would be the pages in question circulated prior to April 2017 would be stricken and not be sufficient signatures placed on the ballot. Is that correct?
I think technically you probably have to have 2 votes, one to roll on the motion to strike and then one to grant that paragraph of the objection.
Further discussion?
Just a question, just kind of pacing through, I know we're talking numbers. I just want to make sure, I haven't gone through every single one of these sheets to make sure that there's not a random date from 17 mixed in the first 200 some odd sheets. Have we done that due diligence to make sure that we're not striking or that everything is what it says it is? Just, I haven't had time to go through this entire huge pack to make sure that there's
Well,
no...
I'm sure the parties can stipulate that if the petition sheets circulated prior to April of 2017 were stricken, there would not be sufficient signatures to place the matter on the ballot. Is that?
That is correct.
Okay.
Yes.
Okay, so...
Okay, so
We're dealing with the motion to strike. Paragraph 11 of the motion to strike, which attacks the petitions circulated prior to April 2017 on the basis that it's confusing and misleading. The signers would have expected the petition, or I'm sorry, the question to be on the April ballot. Is that correct? I want to make sure we're all very clear.
Yes.
Yes.
I just want to make sure I understand which way I'm voting. So,
There has to be some movement. The motion would be either to sustain or deny the proponent's motion to strike paragraph 11 of the objector's petition. Is that correct?
That is correct.
And in the alternative motion would be a motion to grant the proponent's motion to strike paragraph 11 if the board believes that there is no confusion, that these should have, there is no start date.
so someone has to make a motion?
Yes, absolutely. So we're all clear, with these, there is no start date, end date. Right now, it's wide open. You know, we hear arguments, you know, both in favor and against, but, you know, I think that you need to draw in, for each of you individually, whether or not you truly feel there is confusion caused by this.
Okay.
Sure.
Okay, so I would like to make a motion to sustain the proponent's, what is this, motion?
It would be the...
Motion to strike,
It would be the proponent's motion to strike
paragraph 11 of the objection.
Which means that,
They're going to continue to be allowed.
correct, and paragraph 11 of the objector's petition is removed, if you will, and I'll go through.
Okay.
Once again, to be clear, the last general election held in the village of Forest Park on April 4th, 2017, multiple petition sheets were notarized prior to that date and had been submitted as part of the referendum petitions. Multiple petition sheets indicate that they're seeking approval by the majority of the electors voting on the question at the next regular election were signed by voters and notarized prior to April 4th, which would have been the next regular election after the petition sheets were signed and notarized. Each and every petition sheet bearing the notarization date prior to April 4th, 2017 must be stricken because since they cannot be used in support of a referendum occurring after that time, which was the next regular election at the time of notarization. So a motion to strike, a motion to sustain the motion to strike throws out paragraph 11, and those petitions stay in. A motion to deny will effectively, on the next vote, grant or sustain the objection, and those petition sheets go out.
Okay.
All right.
Heard a motion to sustain the proponent's motion to strike paragraph 11 of the objector.
Correct.
Is that correct?
Yes.
Is there a second to that motion?
Yeah, I'll second that.
You want to have some continued discussion?
I do want to make a comment on this. I think that, you know, you can't have it both ways in this. I think that this is very clear cut, that the election code is silent on how long people have to circulate. I think that there could be voter confusion in here, but there's nothing that I found in the election code or anything that anyone said that says it needs to be circulated between, you know, this date and this date. So how can we turn around and say, well, we're just going to arbitrarily set a date? I understand that there's elections and it's kind of a moving target. So it's challenging for me to sit up here and say, well, yeah, this is, you know, on the previous arguments where we have to do strict compliance, and then say, well, we're just going to arbitrarily create some date in our mind, even though the election code is silent. Because the election code is silent, I think that we have to move to sustain the proponent's motion to strike paragraph 11 of the objection. Just because the election code is silent on this issue, I think the courts will eventually rule that, you know, whichever way they decide to go, there's going to be some clarity on this issue. But where we're at right now, the law is the law is the law.
Okay, so we've got a motion to sustain the proponent's motion to strike paragraph 11 of the objector. All those in favor signify by...
Let's, if we do
We'll do a roll call vote, okay?
Commissioner Mannix.
Aye.
Clerk Moritz, aye. Mayor Calderon.
Aye. So we have obviously sustained the proponent's motion to strike paragraph 11. So we're going to continue after the chair is going to invoke executive privilege, and I need to take a 5-minute break. We can entertain a motion to recess.
So moved.
Second.
Okay, all those in favor say aye.
Aye.
Opposed, there are none. We're going to recess for 5 to 10 minutes.
So moved.
Got a motion to reconvene. Is there a second?
Second.
All those in favor say aye.
Aye.
Aye. Opposed, we are reconvened. Madam, Ms. Moritz, would you take a roll call, please?
Commissioner Mannix.
Here.
Clerk Moritz, here. Mayor Calderon.
Here. Okay, so I think we're going to move on to an additional motion. I think where we left off, we were going to take up which paragraph?
I think the remaining matter is the motion to deviate from the statute on the 40% or on the 25%. As part of the motion to strike.
That's correct. I thought maybe we can vote on that.
Do you want to make any argument?
I know, I said we,
Oh,
stand
okay.
up papers on that.
Mr. Mullen on that it's not within the jurisdiction of this board to address a constitutional issue.
Okay. Part of the motion to strike was to deviate from the Video Gaming Act, which provides 25% of the registered voters in the village. That's the signature, the minimum signature requirement. Mr. Mullen's motion asks that we go to the default provision, which is 8% of those that voted for governor, correct?
Correct.
And cited a federal case, the federal district court case, supplement. It's a federal district court case. I don't have the site handy, it's in my packet, which alluded to the fact that that 25% requirement was unconstitutional. couple things for the board's consideration. That was an advisory referendum. This is a binding referendum, the Georges versus Carney. But it is my recommendation to the board that they move to deny that part of Mr. Mullins' motion for this reason. The board has no jurisdiction to rule on a constitutional issue or to, in effect, overrule a statute. The gaming board statute is clear as to the requirement. So it would be a motion to deny.
Motion to deny based on the fact that we don't have standing to rule on the constitutionality of this.
Jurisdiction.
Or over jurisdiction. Or overturn a statute. Clear statute.
Second.
Any further discussion? Then, Ms. Moritz, you can call the roll call.
Commissioner Mannix?
Aye.
Clerk Moritz, aye. Mayor Calderon?
Aye.
Then we are left with the issue that we discussed earlier, whether or not to strike these 6 non-conforming petition sheets or strike all petition sheets as a result of the 6 sheets that requested be placed on the November 2016 election. Correct? Is that-
Yes, the heading issue.
We're left. Okay. Board, what-
And then, are there going to be matters we're going to take up after this ruling?
Mr. Nally, you said you have to be downtown at 2.
I have an election case up at 2 in the circuit court, yes.
I think we would have to, depending on the board's ruling as to that issue, I think we still need to do the records exam, because if a non-prevailing party is going to file a petition for review, and depending on what the circuit court says, then the signature count is going to decide the issue.
I would just suggest that depending how the board would rule on this legal issue on the heading, it would probably moot out the need to do Rule 6s, because it would be dispositive on the objection as far as that goes.
Well, I think we should take the vote and then decide what the issues that result from it are. But if we're going to go to circuit court, you want the circuit court to rule on whether this should be on the ballot or not. And the only way for them to do that is to go through the process of the Rule 6 appeals. But that again is a decision for the board.
Okay.
Yeah, I mean, normally if a legal issue is dispositive, boards will not get into factual issues, which the Rule 6 would be.
But if the circuit court, depending on which way it goes, if the circuit court reverses, then what are we left with on the signatures? Well, I think actually, there may be, Rule 6 may be moot then.
My experience with other boards is that if they decide a legal issue that's dispositive, they don't get into the factual issues. They just say it's moot at that point because at that point the objection would have been granted. But obviously that's up to how the board rules on a legal issue.
Again, can't the circuit court remand it back for Rule 6?
Not on a legal issue, and they could remand it back if they reversed on the legal issue, if the parties didn't take a further appeal.
Well, let's finish this last issue and then discuss that a little further. So that is the remaining issue, the 6 non-conforming petitions.
So that's what's before us to make a decision on, and that is whether or not, we should apply the language of 710, which allows for substantial compliance, or whether or not we apply 28.3, which clearly says shall. They obviously are different. What's 28? Yes.
Well, I think we're bound by section 28.3, it is the interpretation of 28.3 that's at issue. If they're not complying, do we strike the 6 or strike all petitions? Again, the issue is, where is the deviation? Is it just the 6 in their surplusage, or does 28.3 mandate that every single petition be the same? And it's all or
Let's
nothing,
review
if you
what
will.
let's review what it says. What does it say?
Petitions for the submission of public questions shall consist of sheets of uniform size. Each sheet shall contain, above the space for signature, an appropriate heading giving the information as to the question of public policy to be submitted, and specifying the state at large of the political subdivision or district or precinct, combination of precincts in which it is submitted, and with law which at a particular election. I'm looking for the specific. The heading of each sheet shall be the same. Petition shall be signed by the registered voters of the political subdivision, et cetera, et cetera.
With that being the case, I mean, that makes things very clear that they should all be the same.
They should be. They should all be the same, but the sanction, if they are not all the same, is the conundrum, if you will.
And that's what's that question, whether or not you pull out the 6 or don't allow any of them. I don't see any other choice.
So if we were going to make a motion right now, we would have to make a motion and distinguish what the remedy would be?
No, it's going to be, well, to deny the motion to strike, which then is granting a motion to sustain the objection. Mr. Mullins' motion is that substantial compliance applies here, and only those 6 non-conforming sheets should be withdrawn or stricken. And if the board is inclined to agree with them, it's a motion to sustain. If the board is inclined to disagree with them, it's a motion to deny his motion. Correct? And then the next motion would be sustaining Mr. Nally's objection. In the alternative, if the board, well, you can make motions, take a vote, if it's passed, and make one in the alternative. Or again, if you are inclined to agree with Mr. Mullins' position, it's a motion to sustain. Discuss it further.
We can make the motion and discuss, correct, after we make the motion?
Motion is second, discuss.
Absolutely.
Okay, I'd like to make a motion to deny the proponent's motion to strike paragraphs
8, 9, and
we have to do 8, 9, and 10 together?
I think it's all part and parcel of the same, correct?
Okay. Deny the motion to strike 8, 9, and 10.
Second.
Okay, we'll continue discussion.
This, in my mind, is a pretty cut and dry issue. It's shall be the same. They're not the same. And asking us as electoral board to say, well, we're just going to ignore that is, I don't think, appropriate from a legal perspective. 23 is very, very clear. And then furthermore, when you kind of look at the totality of what's in front of us, and Mr. Mullins, suggesting that we simply strike those 6 sheets, I believe that also, calls into question whether or not they're trying to alter a petition back after it's been filed, which is also prohibited by election code, which is concerning me. I can't in good conscience sit up here and say, well, we're just going to ignore that just because you got close enough. There's nothing in 28.3 that I found anywhere in the referendum section of the statute that says get it close. There's no remedy for that. If it's not there, it's not there. It's unfortunate. It's not there, though.
Any further discussion? This will be a motion to strike.
No, a motion to deny
To deny.
Mr. Mullins'
Strike
proposed motion to strike 8, 9, and 10.
9 and 10.
Okay, if there's no further discussion, Ms. Moritz, you can call the roll call.
Commissioner Mannix?
Aye.
Clerk Moritz, aye. Mayor Calderon?
Aye.
That having resolved then, and gentlemen, you're standing on the same arguments, correct?
Correct.
Yes.
And it is denied, and the board believes that all petitions should be stricken as a result of the 6 non-conforming petitions referencing the November 2016 election. So the motion would be to sustain the objection as raised in paragraphs 8, 9, and 10. That includes the issue of the pattern of fraud, which really is not an issue because I don't think we even need to make a ruling on the pattern of fraud because the board has already determined that the remedy is strict compliance.
On that note, so if we're going to make a motion to sustain the objection, whereas 8, 9, do we have to include 10 in that as well? I don't feel like we had any real argument or back and forth discussion about any fraud. It was mentioned a couple times here or there. Where really, I think the issue is, paragraph 8 is kind of where I'm. 8, 9, 8 being the primary,
Correct.
9 being the secondary. Pardon?
Sustain 8 and 9.
Okay, I'd like to make a motion then to sustain the objection in reference to paragraphs 8 and 9.
Correct. The objector's petition.
I'll second.
The objectors 8 and 9 and 10?
No,
Just 8 and 9?
I mean, 8 and 9 are dispositive of
Yes. Okay, is there any further discussion on that motion?
No.
If not, Ms. Moritz, you can call the roll.
Commissioner Mannix?
Aye.
Clerk Moritz, aye. Mayor Calderon?
Aye.
That being said, then, it's dispositive, the objector's objection being sustained, there are not sufficient signatures to place the public question on a ballot in the Village of Forest Park.
Do we have to take up 10 and do anything with 10, or is it just kind of just left out there?
No, it's disposed of. It's disposed of. So, two things. We have to reconvene for entry of the final order. Written order. I tried to prepare orders in the alternative, but there are just too many alternatives. And if we can, just a little bit discuss the records exam. You believe it's necessary, and Mr. Nally, you believe it is not.
I believe it's more efficient.
I think actually legally, with the ruling the board just made, it's dispositive. All the petition sheets have been invalidated. So the issue of how many good signatures there are in those sheets or how many bad signatures is not relevant anymore. It's moot because all the sheets have been stricken. So we don't need to go through line by line and decide if the signature is good or not.
Unless the circuit court reverses.
Well, even if the circuit court reverses, the legal issue would still be alive for an appeal up to the appellate court. So again, it's moot as a factual matter because it doesn't matter if there are 2,000 good signatures or 1,000 good signatures, all of them have been stricken by the board's action in invalidating all the sheets. So it's really moot, there's nothing to go forward on.
And if the circuit court reverses, I assume either side is going to take it up on the legal issue.
Well, if the circuit court reverses, we won't take it up.
I'm sorry. It's January.
You sure?
If the circuit court affirms, you're going to take it up.
Awesome.
Okay, and you would also if it was reversed.
Yeah. I'd have to speak to my client, but I would think we'd want to just, we'd want to have a legal issue decided.
Certainly
by the
nice
highest
to have some
possible.
clarity in the statute.
Yeah.
So it's dispositive as of today, but subject to the court, we may have to convene again for the purposes of going over the signatures, correct?
If the court's reversed, and let's assume reverse said the appropriate remedy was striking the 6. There may be sufficient signatures, even with the Rule 6. What's convenient for you, gentlemen?
That's up to you.
For the board,
Your
this would be for the board just to sign the dispositive final order?
You're not going to be, you don't need to be here.
I would waive formal appearance and accept service by email whenever the board signs the order.
Mr. Mullen?
Same.
Okay.
Just on the records exam, I got a question on that. So in terms of process here, we're going to come back, vote on a final order that will then be served on.
Well, it's going to be sign the final order. The
Sign it.
board has already made its.
Right, just so that there's paperwork and the two parties can go pursue whatever
Correct.
remedy that they choose. We will then adjourn. Does that then force the opponents or proponents to have to go back and do another binder check? Or those records preserved, or if it is remanded back to us?
It's preserved.
Okay, I just want to make sure we're not having to duplicate efforts.
Well, we're going to have to reconvene.
Correct.
At least for a short period of time. So we're only going to be recessing anyways, right?
Today.
Until when we establish the next date.
Friday morning, Friday afternoon. What's
I can do Friday afternoon, but I have a board meeting Friday morning at the Thompson Center.
Friday afternoon?
Friday afternoons, I prefer to have it done before the week's out.
What time are you thinking? Could we do like 3 o'clock?
Yeah, that's all I mean.
Okay, before I entertain a motion to recess, we're going to allow public comment. And so anyone interested in making any public comment, we simply are going to ask you to just come up to this podium here, and we'll give you a minute or two to make your comment. Please proceed.
Sorry, I'm nervous. I
Um,
don't usually do this.
We don't need to swear the public speakers in, but we do need you just to identify yourself, because this is all a matter of public record.
Oh, okay. My name is Dan Marcus. I became a homeowner and resident of Forest Park a few years ago. Having moved here after the water bill survey and the non-binding referendum took place, I am hopeful to have my say on the issue with this binding referendum question. I also know that I'm not alone, as there are thousands of residents who signed this petition. We all want our vote, and the election board should be, fighting to uphold the citizens' right to that vote. I'm most saddened to witness a small but powerful group side with the gaming lobby over the community that they are here to serve. Encouraging voter suppression and obstruction tactics simply to make money is corruption silencing democracy. The community has asked to be heard time and time again on this issue, but by dragging this out, it has continued to divide the community. Every day, online, in the streets, and in the papers, we are seeing name-calling and character assassinations and misinformation, and it's sad and it's ridiculous. We don't need to be here today. The village council could have allowed the vote regardless of these petitions. They could have decided to listen to the constituents' pleas for the vote 2 years ago. All we want is what is right, and again, it's in your hands. I urge you to stop wasting I urge you to stop wasting even more time and again, all this money. The people not only want a vote, but they want to be free of this cronyism and conflict of interest. So let's just vote already. Thanks.
Any other public comments? All right, I'm going to entertain a motion to recess
So moved.
until Friday, January 26th at the hour of 3 p.m. That's your motion. We have a second. Ms. Moritz, you can call the roll.
Commissioner Mannix?
Aye.
Clerk Moritz, aye. Mayor Calderon?
Aye. We stand in recess.